A warm welcome to today's video here on the Ray Law International channel. In addition to these videos, we also have live webinars each month. Presently, we have live webinars in both Spanish and English. Make sure to subscribe to be notified of our next event. This is a great opportunity to meet our team and have your questions answered live. Now, let's turn our attention to today's topic. There are many types of visas to enter the US, and one of them is called the E2 Investor Visa. Do you have an E2 visa? Today, we're going to talk about whether or not someone who has entered an E2 visa status can change employers. Typically, the E2 visa investor and employees can only work for the company or business in which the investment was made. Here is what you need to know if you plan to change employers. First, if you are working for the parent company or subsidiary, you must have evidence that the relationship exists between those entities. Second, if the employee is working in an executive capacity, they must possess essential skills critical to the success of the company. And finally, that the employment terms and conditions are not substantially changed. Let's briefly talk about what constitutes a substantive change to the E2 status terms and conditions. A substantive change is defined as a fundamental change in the employer's basic characteristics, such as a merger, acquisition, or major event which affects the treaty, investor, or employee's previously approved relationship with the organization. If any of these events occur, it must be approved by the USCIS. The main thing you want to keep in mind here is that you must consult with an immigration attorney as soon as possible if you are considering changing the nature of the business you are conducting. For example, if you have a bar and you want to add a restaurant, this may not be considered substantive, but if you switch jobs, it may be considered substantive. In that case, you will need USCIS's approval before you make that change in order to stay in valid status here in the US. In order to get the transfer done, you must file a new petition along with the e-supplement and ensure that the new business has invested a substantial amount of money. You also want to establish that the employee will still be employed in an executive, managerial, or essential worker capacity, and that you intend to depart the US once the E2 visa expires. Most employees don't want to leave the US to obtain a new visa stamp abroad, so they will file the petition here in the United States with the USCIS. In the alternative, most attorneys will recommend that you file this visa by way of the consular processing because your E2 visa stamp will be granted for a longer period, usually for 5 years compared to the 2 years granted by the USCIS. Another benefit of the 5-year E2 visa stamp by the consulate is that your E2 status will be automatically renewed each time you come back to the US. If you and your employer are considering the E2 option, contact us today for assistance and guidance. Now, more than ever, it is important that you have an immigration attorney involved in your immigration case. Get the Ray Law Advantage. Get the information and knowledge you need to have peace of mind. Stay updated on immigration matters by subscribing to our channel and sharing these videos with your friends and your company. Thank you for the privilege of your time. We'll see you next time.